Meghan Maes, and welcome to the Saturday at 10 event. I have a Facebook group called Being Civil in Minnesota, where I provide free legal information and resources to Minnesota residents, for individuals and families to just kind of know what the rules and process is. I am a lawyer, and I'm licensed to practice in Minnesota. I do practice in district court. This is not legal advice. I just want to make sure that everybody understands that this does not make me your lawyer. You can post anonymous questions, and I will respond as I'm able to give information and resources. And today we had 2 such questions. I do want to thank everybody for showing up, being proactive in the group. If you know somebody that would benefit from this free resource, please send them to the group Being Civil in Minnesota. All right, so today we have 2 topics to cover. The first question is about enforcing an order, and the second question is about modifying or changing an order. So the first question says, my significant other found out he had a child from a one-time thing. We found out when the child was 4 due to being in foster care, and the county contacted him for paternity. Long story short, the mother got the child back, and we saw him for 2 full years due to mother being civil with us. All of a sudden, she stopped all contact out of nowhere, and now we haven't seen the child in 2 years. They don't know where the child is. They've been blocked on everything, and they are continuing to financially support the child. They don't know where the child or where the other parent is. They never showed up to court. They want to know, how do we get the child to see him? How do we find the other parent? 2 years is too long. We miss him so much. They've worked with 3 different lawyers in that time, and just recently they were awarded 50-50 custody as of June 1st. In Minnesota, there's custody and there's parenting time. So I reached back out to this member and I said, are we talking about parenting time, which is the schedule, 50-50 equal schedule, or are we talking about decision making, custody? And they confirmed that yes, they were awarded parenting time. So they want to know, now what? So first of all, 3 lawyers, 2 years, that's a significant period of time to not see your kid. So I really feel that this family has gone through when somebody fights for 2 years just to see a kid, it's real, right? The child was previously reunified with the other parent, and that's because the county's goal typically when they're involved in a case is to reunify the child with the situation they were in before the case started. So what can you do? Well, in Minnesota, if you have a court order, which you have, you are generally supposed to wait a certain period of time before you can go back to court. Now, it's been about 2 weeks since the order was issued, and so I want to make sure that you understand that judges are going to differ into how long it takes for them to find that a child has been withheld. So the statute that talks about enforcing parenting time is Minnesota Statute 518.175. And if a child is being withheld in violation of a court order, the court can order something called compensatory parenting time. And compensatory parenting time is permissive, it's not required. And typically how that works is the court would consider what kind of parenting time was denied, and then they would look at what kind of parenting time of a similar type and duration, if it was a weekend or if it was daytime hours, or if it was a holiday. The court may consider those things in ordering the compensatory parenting time, but the one who was denied the parenting time gets to pick, and they have to do it within a year, unless the court orders otherwise, of course. If the child is continuing to be withheld, they can be fined $500. They could maybe perhaps have to cover your costs and attorney's fees. I know you said you had 3 lawyers. Not sure if any of those costs were able to be recovered, but if the pattern continues going forward, conduct-based attorney's fees is something a court could consider. And then, so what could you do? You could file a motion for parenting time assistance. Those instructions are found on the Minnesota Judicial Branch website. Another option would be contempt. I talked a little bit about contempt in a previous episode. That allows a court to hold the other parent with the consequence of going to jail if they don't follow the order, and sometimes that's what it takes. So that every situation is different. Those are some options. There is also a crime in the state of Minnesota. It's called deprivation of parental rights. There is a bit of a disconnect, I think, sometimes in talking about what can and can't law enforcement do with regards to enforcing a court order. That is more limited unless the court gives them the authority to do something, like law enforcement can or shall take immediate physical custody of the child and do X. But what law enforcement can do is investigate and make criminal charging recommendations for crimes. And there's a crime in Minnesota called deprivation of parental rights, and that's 609.26. So if you are having an issue, law enforcement may not be able to go get the child, but they certainly could investigate the crime of being deprived of either custodial or parental rights. So the second question came from another individual, and they were talking more about wanting information on changing things. When there is a change in circumstances, a court can look at the current parenting time arrangement and see whether or not that remains in the child's best interest, or if there are facts and circumstances that may indicate a change is necessary. So I will read their question. Okay. My child has lived with my ex for 11 years. I was unable to provide for our child and did the best I could, but we agreed it was in her best interest to be with the other parent. This child is now 17 this summer, and now this parent is having concerns about the child's well-being. There is a step parent who is battling some depression since November of 23. But this person doesn't, they say that they find grace in this because this person has also been there. So I appreciate that this is not just a place to drag down other parents, but we can talk about concerns, right? So she is, there's been verbal abuse to this child. We'll go out of the way to make it more complicated for the child. For example, refusing to give the child her SS card and BC in order to get a job. So I'm guessing that means Social Security and birth certificate. This parent also just learned yesterday that they have a child together who is younger and now in truancy court. This joint child deals with mental health issues, which this parent believes is a concern in the other household. Do they have grounds to remove the child? Can the child choose just not to go back? How does this work? And then they said, sorry for the loaded question. To be fair, it does touch on quite a few different areas. But in Minnesota, you can ask to modify a parenting time agreement. When and how much you can modify that will depend on the facts and circumstances. Whether or not you're looking at moving towards more of an equal time, or whether or not you're thinking joint decisions regarding mental health need to be made. It's hard for me to say without knowing what the current situation is. But if you do want to restrict the other person's parenting time, meaning not going to 50-50, but changing it from kind of one primary residence to another, you're going to have to show that the child is endangered physically, emotionally, their development. That's going to need to come either, hopefully the child is getting services, mental health services. School is now over, so those school counselors that are so vital during the school year are not available during the summer, making resources for kiddos who are struggling less available, but there are still resources out there. If they're not involved in some kind of therapy, that certainly sounds like a good place to start. But that will depend on whether or not you have the authority to make those kinds of decisions as part of your court order, or if you have to get the other parent's agreement. And if they're not in agreement, you may have to go back to court. So what could a court look at? While the child is 17, the court can consider the preferences of that child when making a decision, but it's not going to just take that child's preference and be done with it. There was sort of with older children, it can be hard. I'm 4'11". I can still pick up some of the smaller children and physically move them if I have to, but the reality is that we have sometimes fiercely independent children who have reasons for not wanting to go to parenting time. And will you then be charged with deprivation of parental rights? Well, not always. If you have concerns for the children's physical safety, and you were acting it was necessary for you to act to prevent physical or sexual assault or substantial emotional harm. And so it is going to depend on whether or not the judge finds the conduct, the behavior to withhold a child out of experiencing these kinds of concerns, whether or not that was reasonable or unreasonable. So the court will also look at the children's emotional needs. It'll look at the emotional health of the parents. Regarding the other co-parent and the other step sibling, the court is not allowed to consider things that don't impact the parent-child relationship. So if dad isn't encouraging the other child to stay home, or is not doing, things that a normal parent would try to do, or a co-parent as a step-parent, that's the supportive role, then it can make a very big difference. Whether or not, but it doesn't, it'll make a difference, but it can't be the only thing that is considered. We want to make sure that we are supporting people in the mental health community who are engaging in services and acting to try to be their best self. And without knowing more about the situation, I think, that is some of the factors that a court could consider if you are looking to restrict someone else's parenting time. If you do have concerns about your kiddo's safety while in the care of the other parent, I would suggest contacting an agency that can help with maybe perhaps a safety plan to put in place to make sure that some examples would be access to, a fully charged phone, or knowing where your charger is, having, other parents' contact information, or the ability to reach out if they need something during that time. There's lots of things that you can do to enhance the feeling of safety for yourself and your kid when they're not in your care. So that's a little bit for these two individuals. If you haven't already joined the group, please join Being Civil in Minnesota. Share this resource. If you have questions, or you have topics or myths that you want to know whether or not they're true, come on over, ask them on the site, and I will see you guys next Saturday at 10. All right, take care.